Michael Jordan's NASCAR team just suffered a crushing legal defeat that could cost them tens of millions of dollars. The Fourth Circuit Court of Appeals delivered a devastating blow to 2311 Racing and Front Row Motorsports, overturning the injunction that allowed them to compete as chartered teams. What happened next will shock you. NASCAR's charter system operates like a franchise model in professional sports. Each charter guarantees entry into every Cup Series race and provides a bigger share of purse money from the season-ending points fund. The system covers 36 chartered cars for a 40-car field each week. In September 2024, NASCAR presented a new charter agreement to 15 teams. The offer was simple: take it or leave it. 13 teams signed the agreement, though some claimed they had little room for negotiation. Only 2 teams refused to sign: 2311 Racing, co-owned by NBA legend Michael Jordan and veteran driver Denny Hamlin, and Front Row Motorsports, led by businessman Bob Jenkins. The financial stakes were massive. Denny Hamlin later confirmed that the difference between running as open teams compared to chartered entries was tens of millions of dollars. Both teams filed an antitrust lawsuit against NASCAR in October 2024, alleging monopolistic and anti-competitive practices. The teams argued that NASCAR's charter agreement contained a clause prohibiting them from suing NASCAR, which they claimed was anti-competitive behavior. In December 2024, U.S. District Court Judge Kenneth Bell granted a preliminary injunction in favor of the teams. The injunction allowed 2311 Racing and Front Row Motorsports to compete as chartered teams for the 2025 season while their lawsuit proceeded. The teams received all the benefits of chartered status, guaranteed starting spots, and full financial payments. The judge ruled that NASCAR's charter agreement likely violated antitrust law. For a moment, it looked like Michael Jordan's team had struck gold. But NASCAR wasn't finished. NASCAR immediately appealed the district court's decision to the Fourth Circuit Court of Appeals. During a May 20th, 25 hearing, signs emerged that the team's legal strategy was in serious trouble. Judge Paul V. Niemeyer openly questioned the team's argument during the proceedings. Niemeyer said, "I had thought coming in, and you can correct me, that the district court concluded that the lawsuit release clause was anti-competitive, and therefore to protect your antitrust claims, the court wanted you to be able to race, but without a contract that included the release." The judge continued his pointed questioning. "My concern, and I'll just lay it out there, I don't understand the Section 2 analysis. What we need to have is the exercise of monopoly power to exclude competition. I can't see why a release addresses competition in any sense. If you don't want the contract, you don't enter into it and you sue. But if you do want the contract, you enter into it and you've given up past releases. But the omega is that you can't have your cake and eat it too." On June 5th, 2025, the 3-judge appellate panel delivered their verdict. NASCAR won. The court's decision was brutal and decisive. In short, because we have found no support for the proposition that a business entity or person violates the antitrust laws by requiring a prospective participant to give a release for past conduct as a condition for doing business, we cannot conclude that the plaintiffs made a clear showing that they were likely to succeed on the merits of that theory. And without satisfaction of the likelihood of success element, the plaintiffs were not entitled to a preliminary injunction. The injunction was overturned. 2311 Racing and Front Row Motorsports faced the loss of their charter status. The appeals court ruling created immediate financial consequences for both teams. Without charter protection, the teams would become open teams, forced to qualify on speed each week to make races. More importantly, they would receive only a fraction of the money guaranteed to chartered teams. Cup Series teams rely heavily on purse and points fund money from NASCAR. With chartered teams getting a much larger share of that money than open teams, the budgets of both 2311 and Front Row Motorsports faced severe impact. The situation became more complex because both teams had expanded from 2 cars to 3 over the offseason. They purchased additional charters from the now-defunct Stewart-Haas racing team that closed at the end of the 2024 season. NASCAR would presumably take over ownership of these charters since Stewart-Haas Racing no longer exists. If the teams lose their charter status, other chartered teams could receive larger shares of the money designated for chartered teams. Front Row Motorsports currently fields cars for Todd Gilliland, Noah Gragson, and Zane Smith. 2311 Racing has cars for Riley Herbst, Tyler Reddick, and Bubba Wallace. Tyler Reddick's situation adds another layer of complexity. The driver ranks 6th in the Cup Series standings and is last year's regular season champion. He competed for the Cup title in November 2024. 2311. Racing argued that Reddick's contract would have made him a free agent if the team could not guarantee him a charter-protected car. Neither 2311 nor Front Row currently faces risk of failing to qualify for races if they lose charter protection. No race since the Daytona 500 has featured more than 40 teams attempting to qualify for the 40 available starting spots. All but one race since the 500 has not featured a full field. The money remains the critical factor. NASCAR didn't stop at appealing the injunction. In March 2025, NASCAR filed counterclaims against 2311 Racing, Front Row Motorsports, and Curtis Polk, Michael Jordan's longtime business manager. NASCAR's counterclaim alleged that the teams and Polk embarked on a strategy to threaten, coerce, and extort NASCAR into meeting their demands for better contract and financial terms. The most explosive allegations centered on Curtis Polk's role as an alleged ringleader. NASCAR claimed Polk coordinated behind-the-scenes efforts among all 15 charter-holding teams to collectively reject individual negotiations. The sanctioning body argued that Polk tried to form a cartel that would include threats of boycotting races. NASCAR's attorneys cited a Benjamin Franklin quote that Polk allegedly sent to the 15 organizations. "We must all hang together, or most assuredly, we shall all hang separately." NASCAR argued this message, and others pointed to an effort to undermine fair competition. The sanctioning body claimed the teams discussed boycotting the 2024 Daytona qualifying races and had previously boycotted a scheduled meeting with NASCAR executives. NASCAR knew the next step was they could boycott a race, which was a threat they had to take seriously, attorney Lawrence Buterman said on behalf of NASCAR. Jeffrey Kessler, the renowned 71-year-old antitrust lawyer representing the teams, found himself fighting on multiple fronts. Kessler had previously won high-profile sports cases, including the NCAA's lifting of its cap on college athlete compensation, the United States women's national team's pay discrimination case, and Tom Brady's appeal of his 4-game suspension in the Deflategate scandal. But this case presented different challenges. Kessler argued that the Benjamin Franklin quote was extracted from privileged communications and should not have been publicly revealed. He maintained that NASCAR's allegations failed to prove any unlawful behavior, arguing that coordinated bargaining is a standard tactic in business negotiations. NASCAR knows it has no defense to the monopolization case, so they have come up with this claim about joint negotiations, which they agreed to, never objected to, and now, suddenly, it's an antitrust violation. Kessler said outside court. "It makes absolutely no sense. It's not going to help them deflect from the monopolizing they have done in this market and the harm they have inflicted." Kessler described the attacks on Polk as false, unfounded, and frankly beneath the dignity of my adversary to even make those type of comments, which he should know better about. Despite his experience and reputation, Kessler's arguments failed to convince the appeals court. U.S. District Judge Kenneth Bell held a nearly 2-hour hearing on June 18, 2025, focused on the team's motion to dismiss NASCAR's counterclaims. The hearing revealed the mounting frustration from the bench about the escalating legal battle. "It's hard to picture a winner if this goes to the mat or to the flag. In this case," Judge Bell stated during the proceedings, "it scares me to death to think about what all this is costing." Bell pressed both sides on what they hope to accomplish in the antitrust battle that has loomed over the stock car series for months. The judge's comments throughout the hearing emphasized the potential damage of allowing the case to go to trial, both financially and reputationally for all parties involved. When asked what the team sought if they prevailed, Kessler laid out an ambitious list of demands. The attorney explained that among the possibilities was forcing NASCAR to divest itself of the racetracks it owns, 11 of which host Premier Cup Series races. The plaintiffs also want financial damages to be tripled and the ability to compete in non-NASCAR-sanctioned races using the NASCAR-exclusive next-gen car.